Well, I have the tall task of the welcome and the introduction. So welcome. By way of introduction, I am Greg Regal. I am the managing partner of the Tyson's office of McGuireWoods. I wear a number of hats around here. I'm also a real estate land use lawyer. So the notion of a real estate centered topic is not unfamiliar to me. And I wanted to certainly welcome the folks that have taken the time to join us in person. Come on in. And lest you think that you're sort of a smallish maybe group, we've also got upwards of 50 people joining us virtually. So hi to everyone on the video. And I was glad to see so many friends and clients taking time this morning to talk about this topic. The one thing I did want to say is that real estate in general is something that this law firm takes very seriously, and there's a deep legacy of that practice in this office. And in many respects, what we're doing this morning is a good way to kind of highlight the approach we take, and in that the strengths of the Tyson's office, I think objectively, currently and historically, have been real estate, have been commercial litigation, have been construction litigation, and have been labor and employment. And you've got sort of a amalgamation of all those things in the topic today. And it's frankly indicative of the way we try to organize and run the law firm. I think hopefully we recognize that your own businesses are not uniquely siloed. We try to take a holistic approach in terms of just what makes practical business sense, realizing these issues intersect. And some of you may have experience with us in a very narrow aspect of our real estate practice. And hopefully this is an opportunity to see how some of the pieces fit together. The construction litigation part and construction issues and opportunities is something we've invested in very heavily in recent years. And something we're going to continue to invest in. So it's important. Our clients are asking for it, and we're very glad to bring this together today to talk about it. I think the other thing that unites all of the lawyers that you're going to hear from today is an absolute commitment to client service. And hopefully this is the start of a discussion, not the ending point. In that same theme, please engage. All the panelists want to hear from you. It'll be a much more productive conversation if we can kind of talk through things in the moment. Applies to both those in the room and those that are joining us virtually. And I'm completely confident that if you've got follow-up questions after this event, you can absolutely reach out to any of us and we can continue the conversation. So it's a pleasure to have everyone here. I think you're in for an interesting and engaging morning. And on behalf of the entire law firm, welcome and have a good time. And guys, you've had the bad view of my backside for 5 minutes, so I'll get out of the way and let you do your thing. Thanks, everybody.
So my name is Mike Dingman, and with me this morning is Louise Wicker. We're both members of McGuireWoods construction industry team, which includes more than 40 attorneys throughout our offices throughout the United States and in London as well. We are involved in projects throughout the U.S., from multifamily to commercial to data centers to energy projects, and have a very good understanding of the industry, both from the owner side and the contractor side and the subcontractor side. And so what we wanted to do with this presentation is focus on some challenges that we see or some changes in the industry that we think would be of interest to this group. The first one is really Virginia-centric, and it's going to focus on Virginia's enactment of what is effectively a prompt payment act for private projects, and also has eliminated, except for very limited circumstances, pay when paid clauses. So we're going to talk about that Virginia topic in the first session. And then we're going to talk about employment issues in the construction industry, because we've seen a lot of uptick in those types of disputes. Many jurisdictions now make everybody upstream from a subcontractor to a contractor liable if employees are not paid. And so there's some challenges in the employment side of the business that we're going to focus on in the second session. And then the last session is going to focus on everybody's favorite topic, termination. I don't know how many people have terminated a contract for default or for convenience. We've been through that many times, and there are myriad challenges in doing that well. And it's a very difficult, as you can imagine, situation to get to a termination. So our last session is going to focus on that topic and how to get through that unhappy circumstance. So we're going to start now with the first session. So the first session is going to focus on Virginia Code Section 11-4.6, which became effective on January 1. And if you Googled prompt payment, you wouldn't find anything in the Virginia Code because it's buried in the section that talks about liability for subcontractor employees. But what it actually has done is enacted a Prompt Payment Act for private projects, and it's also eliminated the pay when paid clauses that are typical in subcontract agreements. So what we're going to focus on today are what are these mandatory payment periods? How does that affect not only how you conduct your business, but how you write your contracts to make sure you're in compliance? Because these provisions are mandatory. In other words, you cannot contract around them. And there are penalties for noncompliance. So first is taking a look at the key definitions in that code section. So general contractor and subcontractor have the same meaning that's given to them under section 43-1, which is the mechanics lien statute for Virginia. And it's very broad. It's effectively anyone who's providing labor, materials, and so forth to a project. There is one exception, though. The statute clearly says it does not apply to a person who's solely furnishing materials. So if you're simply a material supplier, you're not subject to the benefits, frankly, of this statute. If you're a subcontractor who's doing a little bit of both, supplying materials, but also doing work, you are covered by this new code section. So next slide is just to define the owner very quickly. It's any owner who's not a public body. So the definition is making clear that this code section applies to any private owner who's involved in a construction project. The last key definition is to what agreements does this new code section apply? So construction contract is defined very broadly to include not just construction of a new building, but alterations, repairs, maintenance of a building, excavation, demolition. So it's extremely broad and applies across pretty much any construction activity you can think of. One of the things that's interesting for owners is it includes a reference to maintenance of a building. And so if you have a contract with the owner directly with a maintenance company, that is subject to this code section. So we may not typically think of that as a construction contract, but it's defined to include a contract with a maintenance company. So that's something for owners to think about. So now I'm going to hand it off to Louise, who's going to walk through the owner general contractor provisions of this act. And then I'll come back and talk about the provisions with respect to general contractors and subcontractors and on down, whatever number of tiers you have.
Morning. So the first interesting addition is that the statute not only applies, but it also enforces a provision that has to be added into the owner GC contract. And it requires that you include in your contract a provision that you, the owner, will pay the general contractor within 60 days of receipt of an invoice following satisfactory completion of the work for which has been invoiced. So the shall include provision, that obviously raises the question, if the provision is not in the contract, is there potential breaches before you even start? And then what if the invoice doesn't comply? So what if the contractor submits an invoice that doesn't have all the requirements? Typically contracts have the requirements for what has to be in your invoices. So what happens there? So there is a right to withhold payment. However, that comes with its own strings. All right, are you driving? I'm trying to drive. Okay. So, owner doesn't have to pay amounts that are subject to withholding. There's nothing in the statute saying what can or cannot be withheld. So it's important that you have good withholding provisions in your contract so that it's clear when you have a right to withhold payments. But in addition to that, in addition to having specific language in your contract, if you are planning to withhold any payments, there is a requirement that you notify the general contractor in writing. I'm not driving here again.
Yeah, let me just, so one thing to focus on here is the owner can say, you've not complied with the contract, general contractor, so I'm not going to pay you perhaps at all, I'm not going to pay you in full. And normally, in a lot of agreements, you can simply say, you have to submit a compliant invoice. It has all of these requirements. And if you do not, then I can say no as the owner. What this statute says now is you can withhold invoiced amounts per the contract. And so the question is, if you simply have a general requirement for invoicing, but it doesn't say anything about withholding or non-payment, you should probably be more specific so that there's not an argument that you've not complied with the statute. And as Louise is about to talk about, there are requirements that are pretty significant for withholding payment.
So, did that go forward? Oh.
Yeah, it's just a delay.
So if you do intend to withhold payments, you do have requirements now in the statute that you must notify the general contractor in writing with reasonable specificity of your intention to withhold payment, and the reason for non-payment. Now, the one issue that we have with the statute, there is no notice requirement. So there's no provision saying how far in advance you need to notify the contractor. There's also no provision once the contractor does comply with the invoice requirements, what happens then? Do you go back to 60 days from when the original invoice was submitted? Do you go back to 60 days from when the new compliant invoice was submitted? Potentially, that's something that you could add language in your contract that you would remain compliant with the statute, but sets expectations so you don't run the risk of violating the statute and, again, breaching contract.
And while there's no specific time frame for giving this notice, when you look at the reference to the intention to withhold, would seem to suggest you would have to give that notice before the payment is due, right? So if you're intending to withhold something, that's going to be, I have the invoice, payment 30 days out, whatever it might be in the contract is now due. It doesn't seem to me to be something that's, well, I can let that payment date pass and sometime after that say, oh, by the way, I'm going to withhold some amount of your invoice. So I think the intent part would seem to suggest that the owner should do that prior to when payment is due. But it's not explicit in the statute anyway.
Again, and in addition, there's still retainage provisions, right? The statute does not affect retainage provisions. However, it raises potential issues. So what happens when, retainage is held as normal, and what if the retainage is withheld longer because of punch list items or for any other reason? Does this then give an opportunity to jump back into the statute and say, well, I haven't been paid within 60 days. How is that handled? So the statute still leaves doors open when it comes to that. So retainage provisions should also be included in the contract. Again, what sort of specificity is required? If you're going to hold the retainage for a little bit longer, it would probably be safe to give the same reasons that are required if you're going to withhold another payment that isn't retainage.
And we'll move to retainage in just a second. One other thing I wanted to mention on this slide, though, is the reasonable specificity requirement. Many general contractors could probably say there are occasions where money's withheld from me and I'm not really told why or how much. This now requires specificity. What is the reason for the withholding? And I would say, what is the amount that's being withheld would have to be set out so that it's clear what the issues are. And then as you resolve them, as Louise was saying, when is then payment due? But that's something I think is beneficial for contractors, general contractors, and we'll see there's even more specificity required when a general withholds money from a sub to force those participants to be clear and specific about why they're withholding money.
And then the penalties, per the statute, the penalties for not making timely payments, interest penalties at the prime rate, consistent with section 2.24355, which is basically the prime rate of interest. However, it doesn't mention the fact that, this also raises breach of contract issues, which could be a little more expensive than making interest payments.
So Louise was talking about, I didn't get the slide moved fast enough. You can still have retainage provisions in your agreements. That's not prohibited. But the question then is, when you get to the point where retainage is due, substantial completion, or whatever the provision might be in your agreement, if you withhold retainage for some reason, the statute would suggest that you need to state why. It's because you're withholding payment for work that's been invoiced. And if you're saying, well, I'm not going to pay you all of your retainage, then you need to say why that is. Now, some agreements will say, for example, you can hold back as the owner 150% of the estimated cost to complete the punch list work or something along those lines. But you have to be fairly clear in withholding retainage, because once it's invoiced for work that's done, you're now pulled within the statute. And if you're not going to release that retainage, or you're not going to release all of it, then you're going to have to say why.
And then I jumped ahead of the slides.
Sorry.
Okay, handing it back over to Mike, thank goodness, for the nuances with the general subcontractor provisions.
Yeah. And the prior slide, which showed the interest and all of that, it's the same consequences for a general contractor, subcontractor, and on down the line if they fail to comply with the Prompt Payment Act. The reason we've mentioned a breach of contract is the owner general contractor section says these provisions shall be in the agreement. And so if you're breaching that part of the agreement by not complying, then it may trigger some other remedies that the general contractor has in addition to the Prompt Payment Act, because it's not just a violation of the act, it's a breach of the agreement. So the second part of the act deals with contracts between general contractors and subcontractors and goes on down the chain to lower tier subcontractors. And it requires the same effective payment periods that are set forth in the owner GC section. And it's very clear that it's any contract, whether there's at least one general contractor or one subcontractor, the payment is required for satisfactory performance under the agreement. And it's the same timeframes that apply, excuse me, to the owner general contractor section of the code. And this sets it out. So such contract shall require higher tier contractor, and that means subcontractors as well, to pay lower tier subcontractors within the earlier of 60 days of completion of the work and submission of an invoice, or 7 days after receipt of amounts paid by the owner to the general contractor. So what this does, and we'll see this more explicitly in another section of this code, it prohibits pay when paid clauses. So in the past, you could have, as a general contractor, a pay when paid clause so that you do not go at risk if your owner, for whatever reason, doesn't pay you, and you're not on the hook to pay your subcontractors and on down the line. So this is a fairly significant change in Virginia. because it's setting a date that's the earlier of 60 days. So 60 days is the outside period, regardless of whether the GC's been paid by the owner, regardless of whether the subcontractor's been paid by the GC. So this is something that would, I think, require general contractors to think a little bit more about ensuring their ability to stop work or have remedies against the owner if there's non-payment, because the general contractor, the subcontractors are on the hook now, regardless of whether payment's coming downstream. And as is the case with the general contractor owner agreement, there is a caveat that allows for a withholding of amounts from the subcontractor and it says for amounts otherwise reducible pursuant to a breach of contract by the subcontractor. So the language is a little different than the provisions that deal with the owner and general contractor, but it has the same, actually a little more robust requirement for specifying why you're withholding money from a subcontractor. So the statute states that if the contractor withholds all or a part of the invoice, shall notify the contractor or subcontractor in writing of his intention to withhold with the reason for non-payment, specifically identifying the contractual non-compliance, the dollar amount being withheld, and the lower tier subcontractor responsible for the non-compliance. So it's quite a detailed statement that would have to be made to withhold money from a subcontractor. And for the subcontractors in the audience, you're probably very happy about that. Because there are instances where sometimes money's withheld and it's not clear why that's happening. So the statute now mandates that the reason for withholding be specified. And not only that, you have to state how the dollar amount that's being withheld, why you say there's non-compliance with the contract, and you have to identify the lower tier subcontractor responsible. So there are instances where there may be a claim or an issue between the general contractor and multiple subs for an event that's occurred. And the general contractor say, well, it may be this sub's fault, it may be this sub's fault, it may be a combination of the two. So we're going to withhold payment from those subs. This would say, well, you have to specify why this sub is responsible or why another sub is responsible for whatever the issue is. And you have to specify that dollar amount. So you're not able to say, across the board, it's cost me $500,000 for whatever this issue is. And so I'm going to withhold $500,000 from these subs till I sort it out. Now you have to take steps to be specific about what that sub did, how that breached the contract, and the specific dollar amount that's being withheld. So the other provision that makes very clear that pay when paid clauses are no longer enforceable in Virginia is the one that's on the screen now, and clearly says payment by the party contracting with the contractor shall not be a condition preceding to payment to any lower tier subcontractor, regardless of that contractor receiving payment for amounts owed to the contractor. So in other words, even if you're not paid by the owner, you're still responsible for payments to your lower tier subs. The only exception is insolvency or bankruptcy. So there is now a risk, excuse me, I'm losing my voice up here. There is a risk now upstream down where subcontractors could be liable to subs, general contractor liable to subcontractors, even if payment is not being made. And so one of the issues that this should drive is an examination of your agreements to make sure that there's some protections built in the event that the owner, for whatever reason, is late in paying or stops paying as the project is going forward. The insolvency reference here is a little broad. A debtor in bankruptcy is pretty clear, but is a owner insolvent if they're not able to pay their bills? That may be an argument that you could use to say, I can still, in effect, have a pay when paid clause because the owner is now insolvent, even though they have perhaps not filed for bankruptcy. So from a general contractor point of view, you could still have a pay when paid clause in the agreement and subcontractors and on down the line in the event that the owner becomes insolvent or becomes a debtor in bankruptcy, because the statute does allow for that exception. And I would suggest, putting that in those agreements because, again, what's insolvent? If the owner's not able to pay, you can make an argument that, well, that means they're insolvent. And therefore, I'm not obligated to pay my lower tier subcontractor either. And as I mentioned at the beginning, these are all mandatory. The statute says any provision in a contract contrary to this section shall be unenforceable. And so there's no way to contract around these obligations. And what we would recommend is putting into your agreements very clear bases for withholding, a very clear process to do that complies with the statute so that there's no argument that you're out of compliance and therefore not only subject to penalties, but arguably in breach of the agreement, because in the owner general contractor section, it says these provisions shall be in that agreement. For general contractors, subcontractors, and on down the line, it's deemed to be in the agreement. And so it's, I think, in the interest of everyone in that agreement to have clear standards for withholding, what the process is going to be, and that's beneficial in a lot of ways, regardless of this statutory requirement. So same as before, if this is a failure to pay down the line from contractor to subcontractor, you're subject to these interest and penalties, and you're also maybe in breach of your contract. And so what this code section has done is align Virginia now with other jurisdictions that have essentially made pay when paid clauses contrary to public policy. And so the only exceptions, again, are insolvency or the owner actually filing for bankruptcy. And I would say in the majority of subcontract agreements that I've seen, both representing general contractors and subcontractors, would typically have a pay when paid clause. And again, you can still have that, but it has to be limited to these discrete issues with the owner. But what I also would mean for a general contractor is making sure you protect yourself with the owner by maybe having broader or more robust rights to stop the work or suspend the work so that the costs don't keep piling up that you may have to pay downstream. And as we talked about before, same thing with the general contractor, subcontract agreements. You can still have retainage provisions. There's no prohibition against that. So you can withhold without saying why. You can withhold your 10% or 5% retainage, whatever it might be. But when that retainage then comes due, we think you're then back into the requirements. If I'm not going to release that retainage, I need to be specific about why not. And what that amount is if you're a general contractor holding retainage from a sub. So retainage provisions are fine. It only becomes an issue under the statute when the retainage is due. And if it's not paid in full, then we think you would have to comply with the notice requirements of this code section in order to not be in violation of it. And again, same interest and penalties. And that's our presentation. Any questions, comments from anyone? I don't know online how you can ask a question, but.
I can read it in the chat.
Okay.
So the penalty interest rate is just prime. I know a lot of states have a much more punishing interest
Yeah.
rate for prompt payouts.
It's not a significant penalty. And so you may say it doesn't incentivize an owner, general contractor, or subcontractor to comply. And that's where we sort of brought in the issue of, well, does that put you in breach of your contract? Because it's now in the owner general contractor agreement, it has to be in there. And it's deemed to be in the general contractor, subcontractor. So now it's a contractual requirement. So if you miss that, does that open up the right to terminate for the general contractor, stop work, suspend work? I think that may be the more significant impact because the interest is not, to your point, Jeremiah, you'd normally see in other prompt payment acts from other jurisdictions, much higher penalties or interest rates, the right to recover attorney's fees. So this was clearly sort of a compromise in Virginia to have at least some prompt payment act in place, but not to have it with these kind of significant penalties or impacts. And probably the greater change, in my view, is the elimination of pay when paid clauses. Anyone else?
Is there a good faith or sort of good faith defense if you've got, let's say, out of state contractors now, they're not really aware of the specific provision, they don't consult with the council. Let's say they just enter a standard form contract that has a pay with pay clause that violates this. Neither of them really know about it until, let's say, there is an issue that comes up, and all of a sudden the owner does realize, oh, okay, you're right, let's change it. At that point, is it too late, or is there some sort of breach that's already occurred that would the damages?
I mean, I think you could argue that there's a technical breach by not including it in the owner general contractor agreement because the statute mandates that. But I think in practice, if the owner says, oh, okay, well, now I'm subject to this requirement and starts to adhere to it, then I think they would be okay going forward. And that is something we see because we do projects all over the country, and a lot of large developer owners have standard form agreements that they send out. A lot of general contractors have their standard form subcontracts. And you really do have to be aware of the nuance of each jurisdiction that you're working in. You know, even in the DMV here with Maryland, DC, and Virginia, they all have different statutes that deal with things like payment and pay when paid clauses and so forth. Yes.
So how would a general contractor incorporate into the contract to protect itself since without paying the cost, they're obligated for themselves if even if they're not paid. So contractor they have to.
What I would think is probably the most effective is either the right to stop work, so that now you've stopped the money that you have to flow downstream. You could have a right as well to terminate, but that's something that you have to think long and hard about, and we're going to talk about that in our third session. But from my point of view, when I'm representing general contractors, we're very aware of the period of time that could pass because you're always invoicing a month behind. And if payment becomes an issue, having the right to stop payment sooner rather than later can at least stop the bleeding for a period of time, and having provisions that if you are entitled to stop work, that the cost to demobilize or remobilize and those things are recoverable, so that there's a downside to the owner not paying. But I think that's what I would focus on, is either right to stop work or suspend the work, however you want to phrase it. and a right to terminate if payment's not made within a certain period of time. All right. Well, thanks everybody for listening to this session. We are now going to go to our second session, and that's going to focus on the top 10 employment issues in the construction industry. I don't know if we're going to have a David Letterman sort of show, but John and David are going to tell you all about the employment issues that you encounter in the construction industry.
I think you date yourself if you refer to David Letterman.
That's very true. Yes.
Keep this live. Yeah, thank you all, everybody, for having us. We're excited to talk about labor and employment issues, particularly those with a emphasis in the construction industry. I'm John Thomas, and with me is David Greenspan. We're two of the partners here in the Tyson's office that focus almost exclusively on labor and employment issues. And we've got a top 10 list, not David Letterman style, because we couldn't have any fancy graphics or anything like that, or walk on music or whatever.
Or apparently count all the way to 10, but
We'll get to
figure that out
We'll get
later.
to that. So I think we can go ahead and get started. This is the list that we put together is really just a sort of a summary of things that we've observed over the last 12 to 18 months, I would say, both in terms of issues affecting employers generally and those that affect employers in the construction industry and construction adjacent industries. So we'll talk about independent contractor misclassification, one of those that affects, frankly, all employers. The second thing we'll talk about is artificial intelligence, probably one of the newer issues that's being addressed by nearly every federal agency that is paying attention. We'll talk about OSHA liability for subcontractors, and what's not on this slide is the new fall protection national emphasis program. We'll give you a brief update on I-9 inspections. There was a recent announcement that we'll talk about in that area. Talk about paid time off, non-competes, non-solicits, and other restrictive covenants, pay equity, pay transparency, and finally, drug testing, which is always a fun thing to talk about with construction employers. So, David?
Yep. So thank you all for being here. And for those of you online, hello. If you have any questions or if we say something that doesn't sound right, just let us know. Give us, raise your hand, interrupt us. I know it's kind of hard to make it conversational in this setting, but it's always, I think, a better presentation if we're addressing the issues that are at the front of your mind. So John introduced the two of us. Let me just briefly, John and I have both been here in Tyson's in the labor and employment group for how many years for you? 11 for John, 22 for me. And about 90% of our practice deals with just the employer relationship. A lot of our clients are in a couple different industries and construction being one of them. So we generally represent clients in the construction industry here in the DMV, but we also have a fair number of clients in other geographies. So when we talk about some of the state-specific issues, we're obviously not able to do a 50-state survey. But if we're thinking about something particular happening, for example, in Alabama or Colorado's got a couple things, we'll flag those for you. And if there's a place or an area where you have a specific question, let us know. So let's start with independent contractor misclassification issues. And, this is not a hot topic in the sense that you're hearing about it for the first time, but it is a topic that tends to be the bane of existence in heavy commercial organizations. So first of all, when you think about the distinction between an employee, an independent contractor, a contractor, employment through a general contractor, you can say it a lot of different ways, but it really boils down to one issue, regardless of the tests, whether it's the IRS test, 8722, the IRS has its own test, DOL has its own test, But it really boils down to control. Who has the day-to-day control of the individual or class of individuals that you are classifying? Control is measured by a couple different aspects. Who is managing the individual? What is the worker's opportunity to actually profit from the work they're doing? Again, this goes to a contractor. If you're literally outsourcing a particular function and you're, flowing it through, for example, electrical work, and they're coming in through a sub and the electrical company has their own employees, you look at who's supervising the crew, who's actually generating the profit from the work they're doing, how it's carved out. The amount of skill required is actually a factor that, if you look at some of the more recent reported case law, is being considered more heavily. I think the gist there is, laborers and less skilled workers, to the extent they're anywhere close to that line of contractor, courts and agencies are saying, yeah, don't play games with that. We want you to pay them as employees because of all the benefits and protections that generally come with that. The degree of permanence is a factor. So if you're getting individuals through hiring halls, or if you're hiring them, if they've been employees in the past, if they're temp workers, these are all factors that come into the equation. And then another factor that it's on the list, and I don't know why I'm seeing it more and more, but whether the work itself that the individuals are providing is part of an integrated unit to your operation. So if you have people that do the same work and you're bringing in service providers and laborers to do the same work, that actually cuts against you if you're trying to consider them as contractors or independent contractors. So again, if you take a step back from what I just went through, each and every one of them comes down to what I said at the beginning: control. Who is controlling the individual? And there are some serious consequences that come with misclassification issues. And I'm going to start with not a tangible one, but government agencies and state agencies are cooperating with each other and they're talking to each other. So it's a foot in the door issue. If you have a misclassification, you're generally not paying the contractors in a way that FLSA would say you have to: minimum wage, overtime, and in states, premiums on overtime. DOL and IRS are talking to each other. Immigration, INS, and they all have cooperation agreements, so that if you have any one issue, it is more likely in 2023 than ever that they're going to formally report what is, being seen in one agency to several others. And of course, once an agency comes knocking on your door, you smile, you cooperate, you do the best you can to answer their questions, but they're in. And I think the other thing to keep in mind is we have a case right now in Indiana. I won't get into details, but it's just an EEO case, disability discrimination. And our client had an interview the other day, and the EEO investigator was asking about NIOSH guidelines, which are voluntary. They're not even mandatory OSHA guidelines. They're presumptive guidelines for lifting requirements and things like that. And the EEO investigator was asking questions as if A, the presumptive guidelines were enforceable mandatory guidelines under OSHA, but B, they were tying it to disability issues and talking about reporting to different state agencies. And I had never experienced that before. And that's something that just happened last week. So the notion that agencies are cooperating with each other, it's a real one, and we're starting to see that more specifically. The impacts, I've gone through most of them. You have some counting issues in terms of federal and state law coverage issues with benefits, coverage, healthcare, ACA issues, workers' comp comes into play. And the big one, I think, is just taxes and withholdings, because if you have a class of employees that's, going to be addressed retroactively, it's not just recalculating overtime and paying the individuals. It's going back and paying the government because they want to get their money first, and they're going to look at it under that lens. And we've already noted that it is a heightened area of enforcement for EEOC, DOL, and LRB, to the extent you've got union employees, and as I said, IRS. And the damages, I didn't put a slide up here for what's really at issue, but you've heard all these scare stats. So, there's some criminal exposure for people that sign off on things. There's a $50,000 per W-2 violation. There's a 3% of net worker earnings. And then lots of states come on top of that and say, we want our slice too. I'm in a safe space in that we don't have any state employees here, right? We all have similar perspectives on this. And then the last thing I'll mention is that some states are going to what's called an ABC test, California, Massachusetts, Florida in particular. And that really goes back to where I talked about control. There are presumptions that the states in the ABC test apply to the control analysis, which at a high level just makes it really harder to satisfy that test. So if you haven't taken some time to look at classification issues as an organization, now is a great time to do that. You can do it in an internal privilege setting. There's lots of ways that you can address it going forward, but I would suggest it's one of those internal audit things. If you haven't done it in a while, it's probably worth looking at.
Yeah, I think that last point that David made is worth emphasizing because what I've noticed is that independent contractor misclassification is probably the most hotly litigated issue of all issues right now, both in the private court settings and for government agencies. It is often the case that when a government agency finds out that you're working with an independent contractor, the immediate assumption of the government agency is you're doing it wrong because it's such a high, difficult test to jump over at this point. So I recommend that if you did an independent contractor misclassification audit 3 years ago, now's the time to do it again because the tests are different, the scrutiny is higher, and as David mentioned, the damages are can be extreme.
And actually, let me just add one more thing to that. Obviously, the past 5 to 7 minutes, we're talking about global classification issues, but in doing this exercise, you should do FLSA exempt classification analysis as well, because they go hand in hand. And while a larger percentage of your traditional workforces will be non-exempt, so won't have as many complicated classification issues, that is certainly not the case with lots of your employee populations. So,
and we see that especially in construction with like the distinction between like a foreman and a shift supervisor and those kinds of things. There's a fair amount of case law that shows that can be a gray area for those in the construction industry. So that's a very fact dependent issue. You can't just rely on the fact, the person's title is foreman and therefore X. It's worth doing a deeper dive. Yes, sure.
What do you recommend to general contractors in states that have the flow of liability for misclassification by lower tiers where we're not able, I work for a general contractor, we're not able to necessarily go into the subcontractor's office and do an audit? What do you recommend that general contractors do in checking into compliance for their lower tiers?
it kind of touches on
I was going to
contractor issues.
Let's
So
just
go ahead.
let's just repeat the question for those who are participating virtually. The question was, what do you recommend for general contractors who work with subcontractors who may or may not be classifying their workers correctly, and particularly where there's a concern that there could be liability on the general contractor if there's a misclassification issue. I always like to start with the contractual relationship between the general contractor and the subcontractor, make sure that there are reps and warranties in place and indemnification agreements in place for that very issue. Now, I also realize the reality of things that sometimes subcontractors will agree to all kinds of indemnification that, practically speaking, they may or may not be willing to agree to when the rubber meets the road and is actually, it's actually triggered. But that's where I like to start, is making sure that it's very clear where the indemnification flows from. That's where I like to start.
Taking that one step further, I'm thinking of workplace incidents where you have, your employee supervised by a JV partner's, supervisor, and then you've got witnesses who are somewhere else. And another piece of the contractual relationship, in addition to indemnification, is adding language in there that gives you investigation and access rights so that you actually have some leverage. Again, at the end of the day, the indemnifications get you only so far. But if you have a contractual right with regards to what you can access, employment right, and again, this cuts both ways, right? Because we don't want to create joint employment, and we don't want to create a situation where you actually have more control over an individual by doing these things. But I do think clauses regarding collaboration and access is a really good way to mitigate in addition to indemnification. Long the short of it is, though, you're right. I mean, you bring these people on, you ask them to do certain things, and the liability flows at some point to you. You only want to look so hard, I guess is what I would say.
And we're going to talk a bit more about that in a moment, because we're going to talk about some of those generalist subcontractor relationships and best practices. I think it's maybe one or two more topics from now. So we're going to touch briefly about, were there any questions on that topic? We're going to touch briefly about artificial intelligence because it seems like it's, at this point, if you're doing a top 10 list of any employment law issue, if you don't mention artificial intelligence, it's professional malpractice. Because if you ask any government agency what the most cutting edge pressing issue for the future, artificial intelligence is going to be on the list. There have been just a slew of government agencies who are interested in exploring and regulating this. The EEOC has been one of the agencies at the forefront. The Commerce Department issued a request for information a few months ago. The FTC, this has been on the FTC's radar for a while. And again, these are agencies that are not always on employment lawyers or those in the construction industry's radar, but it's going to affect us in a big way. I think for most employers generally, and those in the construction industry in particular, probably where this is going to arise in the nearest future is in hiring and using hiring tools to identify populations to work on projects. The EEOC has issued a few pieces of guidance on this that I think are worth taking into account. And at bottom, it involves the fact that, look, if you're using any sort of technology these days, there's likely some component of AI in it. A lot of times, employers are using tools that are supplemented or augmented by artificial intelligence, and they don't even realize it. Artificial intelligence has been something that we've been using in our day-to-day life, and oftentimes you don't even know it. Things like autocorrect on your telephone when you're texting somebody, right, is a form of artificial intelligence. When you're searching on Google and Google is prompting to fill in the rest of your Google search because they know before you do what you actually want to search for. That's a form of artificial intelligence. But now with as artificial intelligence has become more sophisticated, and we're seeing hiring tools being able to use it, for example, to review resumes, to participate or to help identify employees to pass the first level screening interviews, those kinds of things. This opens up a whole new world of issues under anti-discrimination laws in particular. And also with the contractual relations between you and your vendors. So if you're using a staffing agency to identify populations to work on a new project, this is something that you really need to be mindful of to understand what tools are they using, because staffing agencies can be held liable under the anti-discrimination laws. And as a joint employer, in some circumstances, your companies could be as well.
Can I give just a real quick, real live example? Client in El Paso, not in the construction space, but staffing very quickly and heavily. So they used an AI tool, and the AI tool goes, we need to get good employees. Well, I'm going to look where they went to school. I'm going to look at their tenure. I'm going to look at how long they lasted at their last jobs. I'm going to look at their zip code because I want to see how close they live to the site. These are all independently neutral, right? And so the machine learning is actually aggregating information and coming out with something that it's going to look at to give you a list of employees that you can use. We had a situation where we ran disparate impact, which is where you actually look at you look at the numbers to see if there's some unexplainable deviation in terms of what you would expect populations to be for selected and non-selected. And it wasn't Caucasian to African American, it wasn't old to young, it was Hispanics were 6 times less likely to be offered a job than African Americans. And what it turns out was the AI tool was using geography very heavily. And this job site was located in a community where Hispanics didn't live. Hispanics lived more than 30 miles away. So the tool, right, was inadvertently screening out Hispanics to a 6-to-1 degree, which triggered all sorts of, that's the type of AI issue where if you're using it for hiring and you just take a vendor off the shelf products, you could get into issues. And of course, EEOC, not looking at the vendor, they're looking at who is using the software. So
Yeah, and we could spend an entire hour talking about this topic by itself or longer. Yeah,
I know.
Yeah. But what I would recommend doing is just for this brief takeaway, number one, know that your company likely is already using some form of artificial intelligence. And if you're not, you're likely relying on other technologies that are. Facebook, for example, has been in the news and the subject of lawsuits for, your company was able used to be able to post job openings on Facebook. And you could say, I want to hire people from these zip codes with these demographics, et cetera. So even if you think we're not, we're a small construction company, we're not using artificial intelligence, that's for the big guys. Well, no, your HR, person who's putting these ads on LinkedIn or Facebook or monster.com could be using artificial intelligence almost unwittingly. So number one, know that it is quite possible that your company is already involved in this. Number two, know that there are best practices and solutions for making sure that you're staying compliant, either through the disparate impact analyses that we can assist you with, or knowing that you can actually make sure that the tools you're using are being audited. New York City just passed a law that is probably the strictest artificial intelligence guidance out there. So anybody who's got a presence in New York City should certainly be paying attention to that. And then we're just going to touch briefly on data privacy to the extent that you're gathering this information or working with a vendor who is really involved in this. Just know that data privacy issues are a whole nother hour we could spend on, and we won't do that now. But
yeah, let me just add two things. One, EEOC just came out with guidance last week on AI. So if you type in AI and EEOC, this will pop up and you can read it. And that's probably the most recent statement. And two, with respect to data privacy, to the extent that your company flows up to an international parent, that's where data privacy issues, I think, really get difficult, because all of a sudden you're in GDPR land. And if you're aggregating this information and you don't realize it and you're subject to the EU's data privacy laws, that's a place where I've actually seen some clients go, wow, we didn't realize that. And now they've got that issue on top. So
and actually, Virginia is one of the few jurisdictions that has a data privacy law as well. It's in the minority of states right now that has something like that. But since we're in Virginia, I want to mention it. Let's see here. All right, now we're going to talk briefly about OSHA liability for subcontractors. I think there was a little bit of discussion about this in the last session, but there are kind of two things I wanted to talk about in this case. I really want to focus on the multi-employer policy that OSHA has. It's a policy that's been around since the 70s, so it shouldn't be something that you would think is new. But what we've been seeing more and more of in the last year, 2 years, is a focus by both OSHA and state OSHA agencies to find general contractors liable for the OSHA violations of their subcontractors. There are now 8 Court of Appeals, federal courts of appeal, that have expressly held that the multi-employer policy of OSHA is valid and enforceable. The Fourth Circuit has yet to weigh in on it. That's where we are. But what this means is that if you have what they call a controlling employer, generally speaking, a general contractor could meet that definition. And they either know that their subcontractor is violating OSHA, or through the exercise of reasonable diligence should have known that a subcontractor was violating OSHA. it is possible that OSHA could find the general contractor liable. So what does that mean for general contractors out there? And this goes to what I was referring to earlier with the question about what's the best way to protect yourself? I think that there's a multi-prong approach that I recommend general contractors take. Number one goes back to indemnification clauses. Making sure that in your contracts with your subcontractors, it is very clear that subcontractors will be on the hook for their own violations of OSHA. But I don't think you can stop there. I think it also boils down to making sure you have really good relationships with your subcontractors, those with a good safety record, those who you can trust. When they say they're going to be using fall protection, they're actually using fall protection. Knowing that you're not hiring a random subcontractor who you've never worked with before and saying, it's not on us, right? We've got another company handling it. We brought in local Joe, the electrician, to handle all the electrical work, so our hands are clean. It's not going to work like that. And because I've seen an increase in these issues, I think that the general contractors in particular are well suited to make sure that they focus on this issue. The other thing that a few recent, as of 2023, recent case law has shown from the OSHA Review Board is using safety managers to conduct routine inspections of project sites. It doesn't mean that the OSHA has made very clear you don't have to constantly monitor your subcontractors, but demonstrating that you are taking reasonable measures to exercise that reasonable diligence. If you have a safety manager who is visiting work sites, looking for safety violations and doesn't find any, but then OSHA drives around and hops in and does a random workplace audit and sees, oh, so-and-so isn't using fall protection, so-and-so wasn't using proper respiratory equipment. You actually have a pretty strong defense, and it's a defense that has been successful for general contractors this year, where they say, look, we actually exercised diligence, and the evidence was that we didn't observe any OSHA violations. The fact that you happened by and saw it means that you should not hold the general contractor liable, you should hold the subcontractor liable. And there's been some success there. So for general contractors, I recommend implementing a program where you're not turning a blind eye, because I think in that case, OSHA might say, well, if you had actually been exercising the reasonable diligence that the law expects, this would have been in plain view, right? It was in plain view when we showed up. It would have been in plain view if you had even, opened your eye or opened the blinds on the trailer window. So we're going to hold you liable.
Still you.
Yeah, I think there's a lag there.
I might have overclicked.
You overclicked. It's on PTO and leave now.
All right. No. We have a mismatch, so.
That's all right. But the other thing I was just going to mention was, and this was not on the original top 10 list. We had a top 8 list on the first slide, but this is going to be a topic 3B, I guess. For those who were not familiar, there's a brand new national emphasis program on falls. This came out 21 days ago, or became effective 21 days ago. OSHA has a national emphasis program on falls, which means they are going to be focusing on falls, fall protection, and fall protection training as probably one of their more strategic enforcement priorities over the coming months and year. Their falls and fall-related activities are one of the #1 causes of injuries and fatalities. Construction, as you might imagine, is one of those issues. Poor scaffolding or unregulated scaffolding is another one. But for those who haven't seen it, I recommend taking a look at the OSHA instruction that just came out on falls. The big takeaway, I think, for those in the construction industry is know that this is a priority. know that fall protection training is going to be the guidance to the field agents is not going to be overlook it, disregard it, don't worry about it. I think there's going to be an emphasis and enforcement on this coming up to bring those numbers down. Are we on I-9 now? All right, great. This will be a very brief one. For those who, in the construction industry, it's probably a little bit less relevant, but I-9 in general is always a compliance concern. So you may remember before the pandemic, maybe, it's been a while, but pre-pandemic, if you ever hired a remote employee, when you brought them on board, you still had to inspect the I-9 records, their passport or their birth certificate or driver's license, et cetera. You had to physically in-person inspect it. You couldn't just hold it up to a webcam and inspect it virtually. And if you hired, that was true for people working on a construction site. It also included people who worked remotely. You actually had to go and hire a notary to inspect it, right? Almost immediately after the pandemic was announced in 2020, there was sort of a pause on that, and they said, all right, we're going to let employers inspect I-9 documents virtually, sort of as a temporary measure. And basically there were lots of extensions of that policy. Long story short, that the policy of allowing employers to inspect I-9 documents virtually is going to come to an end as of July 31st. Now, that doesn't mean I don't have to worry about this until July 31st and just new hires after that. What that means is that everybody you've been hiring or that you have hired since March of 2020, you will now have to conduct a physical inspection of their I-9 documents. Because again, it wasn't so much a hold it up to a webcam and we're going to check the box and never have to worry about it again. The idea was always, whenever they come back in person, we will then have to do this process over again. There's a bunch of guidance from the federal government on how to do this, including, what if they virtually showed me their passport and now they want to show me their birth certificate? What if the person who initially observed the documents virtually is no longer employed by the company and now they're showing it to a new HR person? What box do I need to fill out on the I-9? What happens if a name has changed on it? There's all kinds of issues that have come up, as you might imagine. Just know there's lots of guidance on this. It's an issue. If you have any questions, we're happy to help you on a one-off basis, but put that on your to-do list.
Okay, let's switch gears and speed up to PTO and leave. So interestingly, construction is the lowest percentage of employee population that gets leave rights. According to the U.S. Bureau of Labor Statistics, 54% of construction workers actually have paid leave rights and benefits. Of course, in the past 10 years, we have lots of state and local laws that are saying you have to provide paid leave for certain criteria. We're not going to be able to take a deep dive into this, but I just want to flag a couple issues, right? So first of all, counting issues. If you have if you are in a state, some states count by the number of workers in the state, and some states will require you to count on an enterprise basis. So make sure that you're counting correctly to determine whether or not you have any responsibility under a particular state leave law. And yes, there are some constitutional issues about a state telling you how you pay your employees paid leave in other states, but that's a separate issue for a separate day. Just know that states like California, if you touch California, they are going to expect you to count everywhere and provide these benefits. The other area of, I guess, more recent concern is the types of protected leave that states are requiring. So, 10 years ago, there was FMLA, it was an unpaid protected leave, and whatever compensation or benefits that employees had, that was a function of policy or CBA. Now states are mandating leave for health issues, for family issues, for sick and safe leave issues, voting, some have bereavement. There are lots of Bloomberg Law, to give a shout out to one of the resources we use. They actually maintain these in 50 state surveys, and keeping up on these, anybody that says they're doing that probably has a little too much free time on their hand. But there are resources that you will want to check. And I think just having your HR people being mindful that when you have people who are going out on leave, just because it hits under your PTO policy and you just check that box, you still need to count it as a protected leave in certain states, because there are times where if you give somebody PTO and then they circle back around and they need a protected leave for sick and safe leave, they would be entitled to it again because the first instance of use wasn't tracked properly. So PTO and paid sick leave is tracking externally, tracking internally. And I know that's easier said than done. Just a couple other more recent developments, COVID emergency. So lots of states had public health emergency sick leave programs like California. I keep saying California, but it's true. Colorado, in particular, just 2 or 3 weeks ago, Colorado terminated its PHE leave requirements. But when they did that, and this is what I want to flag for you, they require that when you revert back to the normal pay policy, they have a mandatory poster and notice requirement, because you have to, whenever you make a change to pay, right? There are some states where every time you adjust pay or benefit, you got to give notice. Some of the states like Colorado say, look, even when you revert back to our old, that's a change and you have to provide notice. So make sure that your posters and your notice requirements are all updated. And again, we can help you with that in various locations, but that was just kind of a nuanced thing. And yes, I'm aware that we haven't talked about Davis-Bacon or service contract or EO 13706, but there's nothing particularly new about that. And this is a hot topics list. So any questions about that, we're happy to answer afterwards.
All right, let's talk about non-competes and non-solicits. I'm going to try and hit a couple of highlights here. Those of us in the room, we are here in Virginia. I thought I would touch on the most recent developments in the DMV area. The first is know that for those in Virginia, non-competes with low-wage workers are, for lack of a better word, unenforceable. What does low-wage workers mean? Well, it keeps going up. I think the latest, I've got it here on the slide. I think the latest calculation of low-wage workers is somebody who makes a weekly wage that annualizes out to $69,000 in 2023. So anybody earning less than that in Virginia is sort of going to be at a de facto presumption that you're not going to be able to have a covenant not to compete with them. Interestingly, in Virginia, it also applies to independent contractors who have an hourly wage. Again, it keeps going up depending on what the Bureau of Labor Statistics says is the average hourly rate across all industries. But I looked it up and it looks like it's around $23.22. So an independent contractor earning less than that would be considered a low wage worker. First of all, if you have a non-compete with an independent contractor, we should probably be having another discussion because we already talked about independent contractor misclassification. And that's one of the other things they will look at. So that's and this isn't new. Virginia passed this law a couple of years ago, but just be aware that that is still an issue. DC, on the other hand, for those with projects in DC, know that DC passed a law last year that, it went through several modifications, but it is now in effect, and it affects, it's probably one of the stricter non-compete laws of anywhere. Anybody who has projects in DC, feel free to email me. I'll send you the chapter on this that has sort of a frequently asked questions.
Actually, I'm going to do a better plug for John because he's being modest. John has written the L&E, the comprehensive book or website resource on DC L&E law, and he keeps it updated and it's available to clients. So I would email John regardless, because it doesn't just cover the topics we're talking about, but pretty much any DC labor and employment issue. It's a really great resource.
I can send them the whole book, but they're going to fall asleep before they get to the chapter on non-competes.
Like I said, my plug was better.
So I think a few important takeaways. The DC law is going to cover anybody who, for again, shorthand, who spends 50% or more of their time in DC. you can have non-competes for people who earn higher wages, that's effectively $150,000 a year. But for the most part, non-competes in DC are going to be verboten. There are some exceptions that we don't necessarily need to get into here. Just know that if you've got non-competes or non-solicits with employees in DC, flag it as an issue. Happy to walk you through it. It's not terribly difficult, but it is the most restrictive jurisdiction in the DMV area. So know about that.
Just like go backwards, like you have somebody that signed a non-compete 10 years ago, that's now off the table, or it's just signed going forward?
Great question. It is not retroactive, so it only applies for contracts entered into going forward.
However, a good plaintiff's lawyer will argue that this statute reflects the public policy of DC in this moment, and will argue that the third prong of the reasonableness test isn't there anymore. So it's not retroactive in the statute, but there's probably a decent argument to actually attack that 2014 non-compete.
And the other concern is that this addresses not just non-compete agreements, it also addresses policies. And so if you maintain a policy of non-competition outside of an agreement, then you could be accused of maintaining a current policy in violation of this as well. So
yeah,
pretty broad.
First of all, just if we're talking about employing and protecting intellectual capital, I think focusing on confidential information is a much safer approach nowadays. If there's an individual or a class of individuals where you need a non-compete or non-solicitation agreement, aim small, miss small. That's the general advice going forward. But I still think now is a moment in time where do you have agreements, for example, with your professional and engineer employees and BD and marketing folks? Are we protecting confidential information? Because if you go into court and you have an agreement, I think judges 9 times out of 10 don't even really look at the agreement. They look at the facts and they want to know, did somebody steal? And you want to be able to go in and not just enforce on a trade secret statute, but have an agreement. And then if there's a non-compete or non-solicit, even better. But make sure that you have that protection. The other thing, I was talking to some antitrust colleagues. We have a standalone antitrust practice, and we are spending a lot more time talking to our antitrust colleagues than we ever have before because of the non-solicitation restrictions, horizontal and vertical restraints that DOJ is coming after all over the place. What Angelo and Reed, 2 of my partners, told me, and they gave me 2 slides that I didn't put in the materials, is there is a procurement collusion strike force. It's an interdisciplinary initiative. They're investigating and prosecuting. So, and that's the key word. They are prosecuting these things. And that is criminal prosecution, not civil prosecution. There are companies who have executives who are facing jail time and real fines as a result of antitrust issues that have been on the books for a while, but really were never part of an enforcement agenda. Since its launch in November 2019, they've had 30 prosecutions, have gotten $350 million in contract claims. And I just want to give you 2 or 3 enforcement examples because I was kind of surprised to see that of the 8 examples he gave me, more than half of them were construction industry issues, which is kind of a scary concept. Multiple examples of guilty pleas on bid rigging and fraud related to obtaining contracts, bringing in service disabled veterans or minority owned businesses to kind of meet certain quotas. And again, when you put those agreements together and you contract with these companies, but you say, we won't touch each other's employees, wink and nod, that's where the problem comes in. That used to be, probably still is in this friendly setting, a fairly common thing to see in a contract. And now it's really something you need to think about because they're coming after it. An engineering firm pled guilty recently and paid over $8 million in fines and restitution for bid rigging on an NC, a North Carolina DOT contract. The executive of the company was convicted at trial and sentenced to 18 months. Again, these come in as fairly innocuous things, and then they come out as, because again, once they start looking at anything, they look at everything. A construction company owner convicted at trial for fraudulently obtaining $240 million in contracts, again, collaborating with small business set-asides. And it was an individual employee who actually challenged the non-solicitations. That's how it all started. That's why, again, I'm talking about one thing and scaring you with the other. I get there's a mismatch, but it's not as much of a mismatch as it used to be. And a former Caltrans employee pled guilty to accepting, isn't related to non-solicit, so I can't use it to scare you. But this is something that if you haven't put it on your radar recently, it is something to put on the radar. And we have lots of really good colleagues who really just practice this antitrust stuff.
Yeah, and I'd be remiss in not mentioning the fact that the FTC has proposed a regulation to basically invalidate non-competes as across the board. That is still undergoing review. It has not been enacted. We're following it very closely. We will see what happens with that. But
So we're good till 45, right, Mike?
Yes.
Okay, good. So we're gonna bring the ship in on time, speed up a little bit on these last two issues. Pay equity and pay transparency. It's actually important to understand the difference between the two, because pay equity is gaining traction, and it's the initiatives that we're seeing companies roll out are actually coming really close to going too far and creating reverse discrimination liabilities with respect to some of their equity efforts. So I just wanted to just very briefly touch on this topic. So pay equity really is an analysis of legal or substantive issues. As you all know, Title VII is the primary federal law that prohibits discrimination, race, sex, gender, national origin, disability. I'm sorry, no, not disability, that's ADA, but right, all the federal laws basically do the same thing. And the law does not allow you to hire people because of protected class. That is, even if you are trying to diversify your workforce, you can't hire somebody or not select somebody simply because of their protected class. It needs to be merit-based. However, for those of you who are federal contractors, you have OFCCP obligations, and there the word affirmative action is used. And affirmative action in that context can be a little bit confusing. It includes training programs, outreach, recruiting efforts, and most importantly, kind of tracking certain statistics on demographics. Certain federal contractors also have to track disabled individuals and veterans under VEVRA. So my three takeaways here: number one, it is good to diversify your workforce, and that can be its own 3-hour presentation. I don't think that's something that we need to spend too much time talking about. How you do it, however, can create serious liability. Cannot have quotas, cannot use numbers. So you can have aspirational goals. We want to, within 3 years, reach a certain threshold or percentage of leaders who are in certain protected classes. Totally fine, permissible, and encouraged by OFCCP and legal under Title VII. But you cannot have a quota. You cannot have an instruction to your HR people saying, I need you to hire X number of this protected class. It's the using numbers to get to the aspirational goals. A lot of companies are using the short circuit, and that's where the liability is flowing. Pay equity really has to do primarily with looking at how you're paying people, right? And if you do a pay equity analysis, I think most companies will see, if they haven't done one in the past 5 years, that there are disparities with regards to pretty much every protected class. You may say we have bans, we're judicious, we focus on all these things. I will suggest to you, if you did a pay equity analysis, and you can do a detailed one, a moderate one, a high-level cursory one, you're going to find inequities in your workforce. And the question is, when do you invest the time and energy to do that? I would suggest to you, based on the theme of what we've been talking about, which is the government is now really enforcing a lot of these employment initiatives. There's no time like the present. And the reason for that is because not only of enforcement, but individuals are far more empowered today to exercise their rights than they ever were before. And they're just smarter and more advised. So being out in front of these things, and I think a pay equity audit, if you haven't done one as an organization in the past 5 to 7 years, I'd put it on the top of your, stretch goal budget for 2023 and 2024 to get funding for it. I think it's that important. And again, that's a little bit of me on a soapbox, but it's a lot of bit of me dealing with clients who didn't do those things and are now dealing with consequences that are just pretty draconian. John, you want to add anything about that?
just quickly on pay transparency, know that there are a bunch of jurisdictions who are passing laws requiring you to actually put your salary ranges in job postings. DC has a bill that is currently considering. I think Massachusetts is going to be the next state to pass it. Just know that that's an issue. If you are a multi-jurisdictional employer, make sure that you're complying with those laws. Again, we could spend half an hour talking about it, but we're not going to.
Yeah, I apologize. Yeah, it's the posting and the notices that really, in the short term, are the procedural requirements. But the big issue to me is the substantive broad look. So we're going to get 1 or 2 minutes over.
I think this might be the last topic. The last topic is drug testing, which is always a big topic. Again, I could spend an hour and frequently do spend an hour talking about this with construction clients. I'm going to do it rapid fire. Number one, lots of states have discounts for workers' compensation insurance premiums if you have a drug testing program that follows state requirements. 99 times out of 100, when I ask a client, hey, are you taking advantage of this? They either say, I don't know, or no, this is the first time I've ever heard about it. So if you like saving money and you're already complying, you might as well look into it. I can help you with that. Biggest trend by far right now is dealing with cannabis. As cannabis becomes legal under state laws, it's frankly becoming harder and harder to find employees who can pass a drug test. And I'm hearing that across a lot of industries, construction adjacent industries included. I think there are two important things to be mindful of. First is reasonable suspicion testing is getting a lot of scrutiny in a lot of jurisdictions. New Jersey probably has the most difficult laws, but we're seeing a trend here, which is no longer is there going to be a presumption that just because somebody fails a drug test, that they were impaired at work, which is, and they're going to say, basically, the current tests for cannabis are no longer reliable. California just signed into law a bill that prohibits employers from using cannabis drug tests that rely on non-psychoactive metabolites, which is a fancy way of saying your normal urine, blood, and hair testing, you can't do it anymore. There are some workarounds, and again, I could spend another 30 minutes on that. Let's talk about DC, Maryland, and Virginia. In DC, they passed a law last year that has not yet been funded. I think it might take effect this year. I need to check the budget to see if it got funding this year. Long story short, it gives broad employment protections for employees in DC for both off-duty recreational and medicinal use. There are exceptions for safety-sensitive workers. So for those of you all working on a construction site where if somebody was impaired, it could result in death or bodily injury, that could be an exception. Virginia has a law that does provide employment protection for people who use medicinal cannabis oil, which has a chemical definition. And again, this is one that trips up a lot of Virginia employers. If you have somebody who either tests positive for cannabis in Virginia or who comes to you and says, I need an accommodation because I use cannabis oil, just call your local employment lawyer and let them know. I know this is an issue. I deal with these all the time, and it's pretty straightforward, but just know that there is a hang up there. Maryland just passed a law legalizing marijuana effective July 1st. There are no, I think they removed, I think in some of the earlier bills, there were some references to employment laws. Those have all been removed. So the law is now silent on employment protections, which is exactly what happened in Virginia, leaving a gray area regarding whether there are or are not protections under state disability laws for people who are using cannabis as a medicine. That's the rapid fire version of drug testing.
But give the happy news, which is it's still illegal under federal law. And for anybody that requires a CDL or under the FHWA where you have to test, you still have to test, you still can terminate. And if there's a state law that wants to say, hey, you can't do it, generally speaking, follow the federal law. That's what we say for
DOT employees, that's true. For non-DOT employees.
Again, I said end with good news and you just can't do that. That's fine. So anyway, thank you all for your time and attention. We'll stick around if you have any questions. And I think you guys are up to your mid-morning break.
Mike stepped away for a second, so we will just introduce ourselves. We are third and final in trying to figure out why we were last. Dealing with termination of convenience or default, it fits well. because it's the last step before. Although knowing that we are the last thing before the delicious food that will come for lunch, we will try not to run long. We'll move quickly, but we'll save some time for questions at the end. And as always, we'll be around afterwards to talk. Just quick introductions. My name is Rick Holtzheimer. I'm a partner here at McGuireWoods. I do construction litigation. And with me, I'll let him introduce himself as Kang, and we do a lot of construction work. Kang and I have worked together on multiple construction projects since he's been here. I put a note, we're trying to figure out where we're, everything from the Chicago Rail, Long Island Rail, solar panels in Maine.
rail projects.
A lot of rail projects. Our favorite is there's a soy sauce factory, a 400 euros Japanese company built a soy sauce factory. That is our favorite. To warehouses and even French drains for, with friends and family. If you're a construction lawyer, you do water drainage outside of townhouses as well for that. So I think we've done everything from the craziest of projects to the most personal of projects for important people. So we do a lot of construction. We love doing it. We love answering questions. And one of the things that I think we want to talk about today is, as lawyers, a lot of times it's with litigation, they come by and they say, we're being sued or we're going to sue somebody, here's the box. And it's like a tax preparer. Tax preparers say, yep, I get all the receipts, and they're like, do it. But we love doing these types of seminars, and we love talking to you all, because to the extent we can talk about what goes into the box or dealing with the issues before it gets to litigation, makes our lives easier. I think it better positions clients for litigation purposes and makes the issues faster and cheaper. So really enjoy doing this. Obviously, we like to be in courtrooms. Lawyers like to talk, but just love the idea of helping you all.
Had 1 minute for that intro. You're really past it.
All right, that's his job here is to keep me in check. And with that, I'll turn it to Ken.
Well, I love doing these presentations because it means I still have a job, which is always a great thing. But the secondary reason is because, and this goes for everyone here, some of the issues we talk about today may not be issues that you are facing currently, right? But as I've learned for my 6 years here, I will help a client with one particular issue, and helping them, I learn about 7, 8 different ones. And those issues somehow come up a year, 2 years down the road. And I recall to myself, oh, wait, there's a case on that. Wait, there's a PowerPoint presentation on that. So I love doing this just for the learning aspect of it. My name is Kang He. I do commercial complex litigation here with Rick. For some reason, my application to Mike's awesome construction sector team is still pending because I'm not listed on that team there. I'm just the CCL part of it. But I like to say it's because I nerd out about contracts. If there's any contract issue involving just one word and the meaning of that word, a comma, semicolon, I love doing that. So when Rick comes in with all the experience and knowledge about the construction experience, I come in with sort of the nerding out of, let's read it this way, let's interpret this way. And I think we make a good team in that.
And we make a good team in that. And true story, we had a case that went all the way up to the Supreme Court where Kang argued in the briefs that the word and meant or, and we won. So when you say he nerds out about language, I remember talking to him and he's like, but and means or here. And I was like, well, why wouldn't you just use or? And back and forth, and God bless it. You got the Supreme Court blessing on it. And so when he says he likes to nerd out about contract language, he is really nerding out about contract language.
Yeah, we could have a whole presentation on that, but let's get to the introduction here.
And so just as an overview as to what we want to do. And with the introduction, obviously, we want to go through some of the general issues. And we know a lot of people here are very experienced in there, but we want to talk about some hot topics and some general issues. We'll talk about the specifics for convenience terminations versus default terminations or fault terminations. And then at the end, we'll do some case studies because it's one thing to talk about a lot of general concepts, but we found a couple cases that really got into termination and raised a lot of issues, and kind of go through that and kind of what the court examined, and we'll even poll the audience here on a couple things. Not fancy if you've done Tom Spons with where you do it on your phone. We'll just poll the audience by hand. We have some questions to see what you think and if you agree with some of our finest judges around here.
Yeah.
Kang wanted to also talk about some caveats.
Well, to highlight one thing from what Rick said, we do have case studies today. I think it's really important because you get to learn about how courts have interpreted certain issues that arise where you have not made the mistake You're not subject to any mistake. Let other people's make the mistake. You guys learn from them. So we're going to do this case studies today. And one specific caveat I want to point out, and I think these slides are being made available, so we'll just call it certain things. If you are dealing with a federal government contract, okay, look at FAR Part 49. Right? We're not going to discuss that in depth today. That is an entire section dealing with how terminations for convenience and defaults work in the government contracting world. But if you're in that sector on any project, go to FAR Part 49.
And so, one thing we want to talk about and just kind of work on the end first, why is this important? Why is proper termination important? And as with a lot of things in the law, because, what are the costs? What are the damages? What happens if there's improper termination? It goes without saying, if there's a improper termination by an owner, there's going to be claims by the contractor for lost profits, lost opportunities, expenses, damages that flow. So that's, from an owner's perspective, if there's improper termination, straightforward damages there.
Yeah. Something for the contractor side of it. So if you are a contractor, either GC or sub, and you improperly terminate, right? Most folks know of this concept already, which is that the person above, whoever's suing you, or if you need to sue them, they would get the cost to complete the project if you improperly terminated. So if you left all of a sudden and it cost them $1 million to finish the project, if you're at fault, they may get that $1 million. But another concept, which is more rare, but really interesting, is that sometimes you don't get that $1 million. Sometimes what you get is what they call the difference in value between the finished project and the unfinished project, or a defective project versus undefective project. There's a case recently in which a contractor was hired to paint a building a certain color. I don't know how they messed this up, but they painted a different color, right? It was like blue. It wasn't even like a Duke blue or a Carolina blue. Like they painted it an ugly maroon red. Sorry, all you Virginia Tech fans out there, but it was a totally different color. And I was like, wait a minute, how'd this happen? So the expert said that to replace that, they'd have to demolish the whole building, right? They couldn't just repaint over it because it was some foundational thing that led up to the paint and all that stuff. So they said, well, we're not going to make this contractor pay to demolish it and redo this whole thing. That'll basically cost, the whole project costs again. I think what's more fair here is that you just pay the market value between a blue building versus a red building. And I kind of look at that, I'm like, well, what is that difference? Is there really a difference? That's pretty nuanced, right? So that may happen, and there's ways to avoid it. If you're scared or concerned about that now, what we recommend is having a contractual clause built in that says, right, if there is a breach, if you improperly terminate, right, we have a right to elect to choose our cost to complete, right? Bargain out of the difference in value zone. If you're the contractor, you might want that. And if so, don't necessarily bargain for it. Just leave that empty. Leave that empty. Let the courts decide that part.
Yeah. And last but not least, litigation costs, being attorneys. And to the extent, I have a position, I don't know if it's controversial or not. I do not like attorney's fees provisions in contracts, unless it's one way. If you can get a one-way contract that helps your side, absolutely. But which is rare, but with respect to attorney's fees, I just find it increases its litigation. People start saying, oh, well, I'm going to push this because we're going to win. And then you try to say, well, why don't we compromise? Do you not believe in our case? Do you not think you're going to win? Are you not good enough to win? And litigation, mutual attorney's fees provision or prevailing party, again, it's a little off topic, but it is something. And I fight tooth and nail on. I don't know if you all, I see a couple of people out there kind of having some experience, it looks like, with attorney's fees provisions, kind of pushing litigation farther than it should. But that's a consideration. And side topic unrelated to this, please don't do them. Happy to give you my pitch later. But I don't like those.
No, I agree with him, and we did not actually prep for that beforehand. Prove that. What I've seen is that if you have a prevailing fees shifting provision like that, right? By the time it gets to a lawsuit, and you're dealing with millions of dollars or even $100,000, both sides think they're right. And if I were to just sample the cases that settle or go to litigation at what stage with a prevailing fee, with that one, most cases with the prevailing one, they usually settle like after discovery, where you've already spent a ton of money on attorney's fees and costs doing that. But where you know that no matter what, even if you win, you're on the hook for that, right? It actually brings people to the table in a more reasonable mindset. So I'm totally with him on that one. And there's reasons to have it, reasons not to have it, we can discuss.
Right. And just touching briefly on reasons to, obviously, and the whole topic here is convenience for default, but actually, Ken kind of wanted to put on a kind of a third category, which is, oh, well, what happens when people are defaulting above you or terminated above you, and what that means.
Yeah. So this is a situation where more so if you're a sub, that's where you should be concerned about. If the owner or the general contractor is all of a sudden, the owner terminates or the general contractor terminates someone above you, right? What do you do then? If you've got a termination for convenience clause already, you're pretty much set. But then I said to myself, okay, but what happens if you don't have one? And I think the answer there would be just look at common law defenses, the frustration of purpose concept. If the person above you has been terminated, the purpose of your contract has been essentially eviscerated. So I think that's what to look for there. I know it's a very simple answer, but I think it's sometimes something that's overlooked, and we don't want to get to a point where you get to that point and then you're like, oh no, what happens? What happens?
So
right, we should be good.
Yeah, we'll and get into that. So that was an interesting take. It's not in the title, convenience default and other, but we did think it was interesting. And just a quick, because Kang says he likes checklists, whether it's David Letterman top 10s or checklists, and we'll get into some details. But
Sports Center not top 10. That's the best checklist out there.
Verifying that there is a termination clause, whether it's just for convenience or just for default, or in some good contracts, both. Yeah. And then with respect to the scope of the termination?
Yeah, so scope of the termination, and let me give you a precursor to all this. This checklist here is not just for the folks in legal or the executives. It's for project managers as well, right? Having a checklist on those important functions out there to make sure you're minimizing your risk, right? I worked for a court in which all we did were checklists for everything to make sure things were done properly, and to have a check like this to ensure, do we have a basis for termination, right? If we do have a basis for termination, right, what is that specific basis? Okay, it says termination for default, but is default defined? Does the contract give specific reasons? Do we fall within that reason? And if so, do we have a right to then partially terminate or completely terminate? Most of the times it's completely, minor cases partially.
Well, and actually Ken brings up, because we've had cases where again, depending on the size of the construction company and what level, where management is very strong-willed, and whether you have a general counsel or legal counsel and some there, and we've seen management like, these guys are doing this, I want them terminated. And with strong-willed people, they'll kind of push through, and we've seen in-house counsel like, well, this is what the management wanted, and it's one thing to say, well, we'd like to do this or that, but if you can go to them and, with a checklist or a list, kind of taking them through the steps, because a lot of times issues become hotter and hotter, and it's hard at that point to kind of cool it down without kind of some sort of process.
And we'll be the bad guys. You could say it's McGuireWoods' fault. We went to a presentation, they said we have to follow a checklist, right? But the checklist is key here to minimize the risk, make sure there's valid termination, and to make sure you provide everything along the way, right? The notice requirements you have to provide, usually writing, usually properly, a cure period as well to let them fix the situation, which we can address later.
And the cure period we want to address here, because there's some, it's easy, okay, just give a cure period. But does mean giving a cure period is, okay, you're on notice, you have 30 days to cure, 7 days to cure, whatever it is. What does that mean when you've already contracted to somebody else to come in and replace them? Is that a cure period? So that's one of the things.
We'll address it later. Yeah.
I was gonna say preview. No, I got a dangle like a preview. So a lot of these, you're like, of course, give the cure period, do the checklist, notice requirements, but there's a couple things in practice.
We're good.
Yeah. And then some post-termination issues, obviously, if it's getting to the point where it's going to be terminated for whatever reason, the idea of just giving notice and just moving on is unlikely to happen. And it's funny, we're going through each of these topics, and I'll let Ken explain too. It's like, but really, whether you call it negotiations or discussions about payment, discussions about materials on site, project documents. I mean, we've had crazy cases where people are fighting over the documents. And the solution was to wrap them in plastic, industrial plastic, and then put them in a warehouse. So that way nobody could touch it without the other side knowing that these documents were safe and acceptable. So all of these, and we can go through the specifics, but it really is the negotiation, or whether you call it a settlement agreement or settlement process or an attempt to settle some of the issues. That is one of the first things we think that comes up in termination.
And we want this presentation to be interactive. So if you have any specific questions about any of these issues now, feel free to ask them. You can ask them now at the end. Two things I want to highlight that recently come up is, what do you do with materials and equipment that are left on site? Most contracts that I've seen don't say, and by the way, if there's a termination, if everything goes to hell, right, we are going to do this with the materials and equipment. Usually it's something that is negotiated, right? The contractors have a right to get their equipment back. Materials, it depends. Have you already paid for the materials? Have you not? Right? Those are things you got to negotiate and figure out. But there's a good way of doing all this, which is just talking to the other side, right? Figuring out a time, the place, who's present. In our case, we had, the wrapping, but also it was on crates, and you literally had to move those equipments with forklifts. So it took about 2 weeks to negotiate all that because everything was involved. But these are all things that could arise afterwards. One other concept are project documents, right? Let's say you've got the general contractor who's basically holding all the documents, and they have not passed through everything throughout the project duration. Make sure you have an accounting provision, right, in your contract. Beyond that, make sure the accounting provision survives termination so that you can say, we have a contractual right to those documents. You may have a right otherwise just because you paid for the project. It's yours. And we're not talking about like emails here, back and forth. We're talking about like certificates, right? Equipment documents, things that are for the project itself specifically. So if you have any questions about this, just let us know. Anything else we'll talk about on this one? That's good.
So getting to the general issues for termination of convenience. Obviously a lot of this comes up at the drafting stage, and what the rights are. And interesting, or maybe to something that people don't think of, is, oh, I'll just put a right to terminate for convenience or default. But one of the issues is timing and provisions dealing with time.
Yeah, so Mike and Rick, they represent a bunch of large construction companies here. And most of the times I get calls not from the lawyers on those, but from the project managers. And I had a project manager call me the other day and say, well, hold on, I've got a termination for convenience provision that I want in this contract. We're the general, we want it with the sub. The sub's never going to agree to it, right? But we need to have some limitation there. I go, well, why don't you put a limitation on it, right? It could be date specific, it could be event specific, and it was unclear when they were going to be awarded the project itself. So they had no idea what event to do. And I said, well, put yourself in control, make yourself the driver, right? Have a provision that says, up until we issue a construction notice to proceed, we have a right to terminate for convenience, right? And you can issue that notice to proceed at any time you want, right? So you can be in control of that situation. Now, if you are the person on the opposite end of it, right, lower tiered subcontractors or anywhere in between, you may not want that convenience provision, and you might not be able to do away with it completely. But if you can limit it, right, it's always good. If you can broaden it, if you're the owner or the GC going downwards, that's always good as well. There's always a competing tug of war there. But make sure that you express your concerns and you're specific with those.
Yeah. And then when getting the basis, a lot of people, discretion as a basis for convenience. A lot of people say, oh, that's a great catch-all. It covers everything. But the reality is, even though it's for convenience, the courts are going to require a good faith requirement. And some people's like, well, but it says for convenience, it says, for any reason, or, you can contract around it, but courts are still going to require good faith. Case after case says, convenience doesn't mean arbitrary, convenience doesn't mean in bad faith. And I have a true story, and it doesn't sound like it's a true story, but I swear to you this happened. I went and I met with a construction client, and we were talking about whether or not they were going to terminate him or what they could do to stay on. And, it was getting to the point of litigation, lawyers were involved. And I walked into the client's office, which was the size of this room. So this was a beautiful, giant office. And he was sitting at the end. He had two assistants there, and he was polishing his shotgun at our appointed time. I didn't know if this was for drama or not. And I said, oh, well, we're here, what can we do? What can I do? Deal with the other side and try to work this out. And he's like, nope, I want them gone. He's like, well, but what can they do? And he said, I'll tell you what, won't terminate them if he agrees to crawl through the mud, get a picture, and publish it in the local paper. And I'm like, ha, 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 we're all joking and laughing. And he's like, that's the only reason, otherwise I want this terminated. And it was just like, oh, and he's like, all right, next appointment, and then shuffled me out. So arbitrarily, so like I said, we talked about strong-willed people, and it depends on the organization, the size, and the ownership. But sometimes, managers can be very strong-willed, and it is the job of outside counsel, inside counsel, and people who are working on the projects to temper some of the more natural instincts of strong-willed management.
Yeah, I think a lot of times, especially if the client does not know the attorneys personally, right? There could be this perception that the attorneys are basically telling us we can't do what we want to do. It's not so much that, it's how do we figure out what the risks are? How do we minimize it? What's the best way to achieve your objective? In that case, it was clearly not to terminate, especially, but the whole shotgun thing really took me for a loop there. And
He was sending a message to me, I think.
yeah. Another reason you can't terminate for convenience apparently is if let's say you are the general contractor and one of your executives goes out to a dinner with one of the owner executives, right? Let's say there's a fight and now they don't like each other. And now one of them wants to exercise the termination for convenience clause. And what's the cited reason? It's not anything project specific. It's not anything related to the work or defects or anything like that. It was because of a bar location, right? Now, in some very limited jurisdictions, that might be okay. For the most part in the DMV, that's probably not okay. You've got to find some legitimate good faith basis. It doesn't have to be a defect. It doesn't have to be a default, right? It doesn't have to be a breach, but it has to be another business related reason. Now, a good argument could be made that business relationships is a good business reason. If I were a judge, I might actually allow that convenience to occur, but that's why I'm not applying.
And then just, so we talked about termination for convenience, and generally just terminations for default.
Yeah, so for termination for default, this is where it gets really tricky. Convenience is usually a lot easier to deal with. For default, right, one of the first things we like to look at is, was there an actual default? Was there an actual breach? Was it just a good faith breach? Was it a excusable breach? And what I mean between actual and good faith is there some sort of third party documentation or witness cooperation to back up the breach? The cases that we love that come to us are where the clients have already hired experts outside of the relationship, a third party engineering firm, a third party construction firm, some consultant to come in and say, hey, we've looked at this and yes, right, there is a problem and there is a link between that problem and the other side, right? So there, I kind of classify as an actual breach. Good faith breach is, well, this is what happened. It's hearsay back and forth. All right, what are the risks there? And then what sometimes we don't forget to do is ask ourselves, right, is there an excuse for that, right? Is it, and I'm not talking about excuse as in, I was late, we got to work late, we couldn't finish on time. Was there a force majeure? Was there a weather delay? Was there outside third-party influence? Was there a parade or a convention that shut down access to the project site? So those are some of the things to look at before we decide to terminate for default on that one. Question? Oh. Mike's eyeing me down like I'm saying something wrong. I'm like, oh. And then the next thing is looking at the right to cure. So some contracts have a right to cure expressly in there, some don't. If it's not in there and a cure period is just saying, okay, we have to notify you of the breach, right? And we have to give you a certain amount of time to fix it. If it's silent, if the contract's silent on that, usually the law implies a right to cure period, right? Other times it's express. If there's no certain time provision given, like say 3 days or 7 days or 2 weeks, it's usually just a reasonable amount of time unless it's otherwise stated. What is reasonable? That's why we love our jobs. We get to litigate what's reasonable, but we've seen some that are 3 days. We've seen some that are 7 days. And so it just really depends on the circumstances, but at bare minimum, at least give 3. Oh, yes.
So regarding right to cure, a lot of the contracts will have clauses that will say something to the effect of, you must cure within 30 days, but if you start within the period, it it's something that cannot be reasonably cured within the 30-day period, you're okay also to start and, in due diligence, you're basically doing it. And then it'll have something to the effect of, but you must cure it within 90-day period or 100-day period, some sort of outside cure dates. Have you ever seen anybody challenge that looking unreasonable, even if it's contractually stated?
So let me repeat the question for two reasons. One, to make sure we understood, and second, for our guests on WebEx or Zoom here. I believe the question was, if you have a cure within 30-day provision, but the actual issue requires more than 30 days to cure, sort of what happens? Can you provide more, or just have we seen that situation before?
It's got to be cured within 30 days, but if it's type of breach or whatever that requires more than 30 days,
Mhm.
you're okay as long as reasonably work.
Start the process, yeah.
Outside cure date, but it's got to be cured within 90 days or X days. So I'm curious as to whether there's ever been challenge as to the reasonableness of sort of the outside closing date for the cure.
I've not seen challenges on the outside, the 90-day cure period. What we see, the fights usually are what is reasonable, because it's kind of the old adage, with enough money, you can do everything in a week. On a construction project, you just throw enough money at it. So then it becomes, so theoretically, anything can be done in 90 days, but how much money and effort and energy is necessary? That's where we see a lot of the push, because, hey, if I could hire, 3 crews to come out here 24 hours a day, I can do it in 90 days. And so it's the reasonableness that we see the fight over, as opposed to the 90.
Is there something that you would advise us to include in contracts? Because reasonable is used all the time thrown around in contracts, but a lot of times it's not provided.
Right.
Yeah, so I can take the first question. Yeah, so it is really hard to pinpoint how many days to give. A lot of times we don't like to think about defects happening. So we go with boilerplate, 3, 7, 14. I think generally in a situation like that, what would happen is, let's make it even more narrow, right? And that might help answer the general. Let's say you only have 14 days and there is no outer 90-day period at all. It's just 14 days. I'm the contractor. I come in and I tell you, well, hold on. This defect is actually going to take 2 months to fix, right? The practical advice there is for the contractor is, one, right? Make sure you have a plan and make sure you've done your due diligence to formulate the plan as to how you're going to fix it. 2, notify the owner promptly, right? Tell them, yes, we recognize it, or say we don't acknowledge it's our fault, but we will fix it, right? Reserving all of our rights. But say, it's going to take 2 months though, and here is why. And list those reasons. It's not going to be extensive, but give certain reasons right there to show that you are approaching in good faith. Because a lot of times what happens is the dispute turns on reasonableness and then the good faith aspect. Was there a good faith effort? If you made a good faith effort, in some cases, that may be enough, right? It may not absolve you completely, but it may say, oh no, hey, owner, you should have terminated them. They made a good faith effort to cure. You should have provided them more time.
Yeah, and so, we've recommended to parties that are trying to cure within that ultimate 90 days, document everything, do as much as you can. Again, you can't throw unlimited resources and money at it, but if you're documenting that, that's usually where we've seen. I've not done that. Mike, have you had any issues where they try to push back the 90-day or say that's arbitrary?
Well, what I would normally see is you would say, if you can't cure within whatever the period is, but you're proceeding in good faith and due diligence to get there, then the question we sometimes have in the contract, well, who makes that call?
Right.
Right. So if I'm the owner, how long is this going to go with the contractor saying, hey, I'm working in good faith, good faith. Same thing for a major subcontractor to a GC. So sometimes we put in a provision, it's my sole determination whether you are actually proceeding in good faith and whether you can actually cure whatever the fault is within the time frame. Because the problem is it can't go on unlimited. And so somebody has to have the right, and I would say it's the owner versus the GC versus the sub, to say, you're past your time, you're not proceeding with due diligence, we're going forward with the default. Now, can they come back and challenge whether you were right? I think they could, and I haven't seen this litigated, but if you say it's my sole determination, right? I'm the harm party, I'm gonna say when enough is enough, and then I can
Yeah.
say you're defaulted. If you have that provision, does that protect you? Because you say it's my sole discretion, and the contracting party says, yes, I will give you that sole discretion.
So, and for the people on video, Mike has a great kind of drafting idea, which is put in there, the owner's sole discretion and determination that the work being done is sufficient or done timely. There just needs to be a cutoff. You put it 90 days in there, but the reality is maybe it's something so fundamental and it requires a lot of work, or there's supply issues, things like that. So putting that is the owner's power to determine is the best you can do. And on the flip side, like we said, if you're the contractor or somebody like that, document everything you're doing, have the lines of communications, send everything. Look, I've reached out to 20 different, bids to try and address this issue. They're coming in, just keep them in there, because then, again, as Mike said, we've not seen it litigated, and hopefully in a good way, because these are being resolved before then. But if the owner is feeling, okay, they made a mistake, it happens, but they are doing everything they can, moving heaven and earth to fix it, then most owners will be good there. But as Mike said, on the flip side, if it's just being dragged out and the owner's feeling like there isn't movement or reasonable efforts, you want that clause in there where it can be terminated.
And sometimes if there's a good relationship between the parties, right, it goes back to a point we had earlier, which is negotiating additional or modifying the terms, right? If you know you've only got 14 days to cure, but it's going to take 2 months to do so, and that's actually reasonable, right? There might be a situation where the owner says, okay, let me see all that. Okay, you know what? I will give you, maybe not 90, maybe I'll give you 90, maybe I'll give you 70, not 9 days, maybe I'll give you 75, maybe something shorter, right? Maybe there is a additional agreement that can be reached on that.
And just being mindful of time, we just wanted to get to our case studies here, because it actually puts into practice a lot of these issues that we've talked about, and I think a lot of the questions you got. So Ken, why don't you just go a quick summary of the facts?
So let me set up the case study first, so you know what to expect and what to watch out for. We're going to set up the material facts here. Then we're going to go into the termination issues. When we get the termination issues, there'll be additional facts related to that specific issue, and we'll ask you about the issue, and feel free to chime in. Right? Say yes, say no, give us your thoughts, and then we'll give you the answer afterwards. So this is a case recently from the Federal Court of Maryland, March 2023, that came out, where the owner had hired a general contractor for a really big project. It's 1 million square foot medical distribution facility for $42 million. Right? There was a retaining wall that was actually built before the general contractor came on board, but it had failed due to excess stormwater buildup behind the wall during the general contractor's term there. The owner then hired a separate, independent, third-party contractor to come in and investigate. That contractor discovered there was a potential link between the wall and the stormwater issues and the general contractor's work. Later on, the general contractor abandoned the job site, and then the owner sent the general contractor a notice of termination.
So as background, so the issue in summary was it a bad design of the retaining wall that was built right before the sale of the property? Or was it the contractor's work that caused some stormwater issues, and there was a lot of design issues with that? So the general contractor, of course, will say, "Oh, it was the retaining wall design," and the owner, of course, was saying, "No, it's your work on the project." So that's the tension in the background.
Question.
Was it for abandoning the job, or was it for the stormwater issue?
Oh, that was good.
Yeah, that's one of the issues. We'll definitely touch up on that. So what I love about some of these construction cases is you get an opinion from the courts, and there's like 5, 6 different issues on there. So you get one opinion to really analyze a bunch of issues. The first termination issue here was that the owner, the general contractor, signed the substantial completion certificate in February of 2019. Okay, and remember, it was initially due in November of 2018, though. So they're about 4 months late here. The owner terminated the contract in November of 2019. And the rule here that the courts apply is that termination of the contract is prohibited usually once one side substantially performs all that the contract requires. So the issue that the general contractor raised was, did the owner lose its right to terminate after the substantial completion certificate was signed? Any thoughts?
Any thoughts on that? Yeah. Yes.
Yeah.
And why?
Because they signed off on substantial completion,
Okay. Any other contrary thoughts?
essentially, space you use as.
Yeah. And there's a lot of case law, and that's the common law that does that. And here, what the judge said, and the judge reiterated that if the common law through states, if you're at substantial completion at that point, you're terminating for a lot of different reasons. Here, there were specific contract provisions that addressed it. And so the court said, while this is the standard law here, as there are a lot of people, they basically contracted around it or lawyered around it. Now, it still wasn't enough for the court to say that the principle didn't apply or it's not going to apply here, but basically said it's going to be a jury question now.
So it could be, right? It could have been. It all depends on the specific circumstances. One specific thing to point out is that substantial completion, once you hit that date in your contract, it doesn't necessarily mean that there's been substantial performance of the entire contract. It just means that, hey, we've hit a point where the owner can come in and do certain parts in it, but there's still stuff left to do, punch list items, all that stuff. And so they said whether the general contractor had performed at that point is going to be a jury question. So it could have very well been. So it's up to you all to decide if you were the jury or not.
Yeah. So, what I think the takeaway here is it's exactly your point. Just a good lawyer tried to contract around it in doing the thing. So thought that was kind of interesting. All right. So our second issue is dealing with the waiver of the right to terminate.
Yeah. So here, again, substantial completion was required by November 2018. It was late February 2019 there. The owner terminated in 2019, November, citing the wall and the stormwater issues though for the reasons for termination. General contractor argued that the owner waived its right to terminate when they waited until November 2019 to terminate when the contract required substantial completion a year beforehand. And I think that the gist there was that the general contractor was saying, look, at some point we missed our substantial completion deadline. You should have terminated us at that point. You shouldn't have waited until November to do so. But
I'm sensing a no from over here on the right.
exactly. No, exactly.
Yeah, so we got to, you should have terminated me earlier, and there's a strong no over here. What was over here on this side?
It should be, once substantial completion, should be the retainage, almost.
It's a retainage issue, right? Right.
Yeah.
It's the wall issue. Yeah.
Yeah.
It's
So,
exactly what let me, yeah.
Clearly the answer is no. So yeah,
No waiver.
no waiver, no waiver. And to the judge went through a lot of different reasons, and one of them was, listen, the owner was acting immediately, and we'll move quickly because we got some issues here, and we want to get to the second case with the cure, which I think is an interesting.
Oh yeah, the cure one. Yeah. If you have any questions about this later, feel free to ask us during lunch.
All right. So the third issue,
All right.
First material breach.
So here it had to do with payment. This might be a concept that everyone's thinking of is if there's a defect on the project, right, or suspected defect, can I withhold payment here? And that's what the owner did. After discovering the issue, the owner started withholding certain payments to cover the damages. The contract actually had a clause that allowed that to happen, either forward moving or retroactively, right, doing that. Did the owner wrongfully terminate by committing the first breach when it failed to make the payments in full under that situation?
Strong no over on the right. Anything on the left?
Any yeses? Because it's a positive word. Maybe we'll throw some
Okay.
yeses.
No,
No.
And the answer is no. It wasn't a first breach because obviously it was contractually allowed, so it was not a first breach. Next issue.
Oh, opportunity to care, which seems to be litigated a lot. So here, I think we might have already addressed this. Contract silent on whether contractors are allowed to cure or not. Throughout the year, the owner notified the general contractor about the issues, and the November 2019 termination letter actually made it effective 7 days from that, which essentially implied we're giving you 7 days to do something. Was the owner required to give them an opportunity to cure even though the contract was silent? And did the general contractor receive an opportunity to cure? So
we touched on it.
touch on the first one. Yeah.
First one, and maybe Kang was signaling, I need a yes here. I need a yes here. Just to move quickly, the answer is yes. Even though it was not contractually in there, because there was a notice provision and a time period before termination, the Maryland court said that's clearly an opportunity to cure. Why else are you giving notice? And that's the time to cure.
And takeaway here is you do not need to have magic words in there such as, please fix this, please cure, notify, right? Just notify the defect. And if you're on the receiving end of it, know that when you're notified of a defect, even if they don't ask you to fix it, you should propose a fix and see if that's viable and try to comply and figure out what the options are.
And the next one, we'll just just go through quickly because I do want to get to the second case, which only has one or two issues, which was the reason for termination, which we've kind of addressed. Ultimately, the court said it was a jury issue, whether or not it was a reasonable, it was not arbitrary. So the court said it was up to the jury. I made it a jury issue. For our second case, we are coming back here to the Commonwealth of Virginia.
Yeah, this is a case from federal court last year, actually, where the general contractor hired a sub to help renovate the Arlington National Cemetery. The project owner had issued a safety stand-down notice due to safety defects, and those safety defects were actually alleged to have been the sub's fault there, okay? The general contractor told the sub to fix the defects or else they'd hire somebody else and the contract would be terminated. The sub submitted a cure proposal, which was rejected. The sub tried to access the site, but they couldn't because of the safety stand-down issue. And then the general contractor terminated the sub.
Okay, so that's your background facts. So getting to our first question.
Yeah. So the first issue there, so get this, when the general contractor told the sub, hey, here's your notice of termination, that same day, the general contractor sent a letter to the project owner and said, by the way, we're not using the sub anymore. We're going to go ahead and replace them with somebody else. Even though we gave them an opportunity to fix this, we're going to hire somebody else. So did the general contractor provide the sub with a good faith cure period there when the general contractor already told the project owner, we're hiring somebody else, we're replacing them? Any thoughts there?
Doesn't look good. Yeah. Yeah. And we got a no, and it doesn't look good.
And it might be no when the jury comes out on this.
Yeah. And basically, the judge was pretty skeptical of that too, but ultimately said that that is a factual determination, a factual issue. She would leave it for the jury. But I think, you know, and actually in her opinion, she did kind of cite some, well, there's some arguments, you know, do you need to start preparing because in case they can't cure, you know, it's a general contractor trying to do the right thing and not be caught flat-footed if they're unable to, which it makes it a classic jury question. You know, from the facts, it was pretty clear it seemed to be kind of a bad faith opportunity to cure. But the judge said, well, there's some arguments that they're raising where I could see somebody allowing that. So basically a no, but she punted it to another day.
And I think the takeaway there isn't necessarily don't be prepared, don't go out there and line someone else up. I think the takeaway there is even if you do that, make sure you still give a good faith, legitimate consideration of the cure attempts, right? Do not just discard them. Treat it as if they're actually trying to fix the issue. Are you considering good faith? But being prepared should not be punished, right?
And then our last issue, and we'll run just a minute or two over, but I thought this was a good way to end it.
Well, Rick actually dealt with this issue in real life.
Different issue.
It's different, yeah, this is the safety stand-down issue. After receiving notice of termination, the sub, of course, couldn't enter the job site because of the safety stand-down order. No one was allowed on the project site. General contractor argued that the cure proposal submitted by the sub did not adequately address how to fix those safety concerns. So did the general contractor provide the sub with a legitimate opportunity to cure in light of the safety stand-down order? In which some additional context there, the sub was saying, yeah, we're ready. We'll go on there. They even tried to access the site, but they were denied because of the safety concerns.
So thoughts, you need to cure it, but you can't come on the site.
Well, I would say it depends on what they said in their cure proposal. Like if what they said that they were going to do to fix the issue was not likely to fix the issue, regardless of whether they went on the site or not. I think it's within, now again, I represent a general contractor, but I think it's within the GC's ability to say that is not a reasonable cure plan. I don't accept that cure plan. I would advise my client to tell them to resubmit before going and terminating. But I think you can't, you can reject a cure plan if it's not legitimate.
And I think, and I agree with that. And the case that we had specifically, where again, the people, the subcontractor was, had safety issues. There were a lot of electricians. It was involving installation of solar panels, a solar panel farm. And so they needed, a certain number of electricians. Also, they were digging these trenches. It was up in Maine. And apparently Maine winters are brutal because it required 20 feet of concrete for each of these pylons, and they were only putting in like 8 feet of concrete, and so there were lots of digging. They were digging large trenches, and there was OSHA violations and OSHA issues for that. And so the owner was like, no, you are barred from the site, but there was a 30-day cure period. And so the back and forth was there. And they said, well, here, we'll do it. We'll pour the concrete. And ultimately we pushed back and they said, well, let us on the site. We said, no, because part of the cure is you need to cure the safety violations, the OSHA violations, the things that ultimately barred you from the site. And so that was, they're like, well, yes, we'll deal with that. We're like, okay, how are you going to deal with that? You didn't have enough electricians. You didn't have the proper equipment to hold back the soil and things like that. And so they were focusing on the curing of the deficiencies. They didn't focus on and really address the curing of the violations for which we barred them from access to the site. So really, that is, so yeah, you focus on the cure, but barring them from the site, you don't want to say that's a cure as well, but yes, you need to cure that first before we'll let you on the site.
Well, I hope you both are correct on this, given that the advice may have already been given. What's the answer?
Well, the answer, as you say that, is it's a question for the jury. But I mean, and the
It
judge
may have been allowed.
It may have been allowed, but the reality is that the judge can't decide
Right.
on summary judgment.
But given your point, that's exactly what the judge says. The jury may find that they did not actively address the safety concerns to go on there. If they didn't, then, oh yeah, that's fine. Here we go. So.
You're in good company with the judge. All right. Well, appreciate everyone's. Went a little bit over, but we definitely wanted to end on this. Thought this was an interesting case and some topics to do. I think there's some food here, Mike. We'll transition to you.
Yeah, just anybody who would like a copy of the PowerPoints, just let us know. Send those to you. And if you have any questions or follow up, people online can hear me, but you can translate it.
I will.
Just feel free to send any of the presenters an email. If you've got some additional questions.
Yeah. For those of you online who didn't hear Mike, he said, we'll provide slides. We're here for follow-ups. You have our emails. He also said he was going to give Kang and I bottles of nice whiskey.
Yes.
To thank us. So thank you.
Beer is minimal.
Anyway, thank you all for your attention. Thanks for the interactive part. It's a good discussion. I mean, these are not clear-cut issues, but we do think there's a general right answer where we think it goes. So please stick around. There's some food, and hope to talk to you all offline.
Thanks, everyone.